share our knowledge. Therefore, being the 200th webinar, keeping in view that they say that every webinar has its own insight and own spirit in its own way, but it's a milestone to be cherished within its own way. Consequently, we requested what we can say a legal luminary who has created his benchmarks in different perspectives of law. We requested Mr. Shekhar Naphade, the senior advocate, on a topic which is quite relevant on today's day, that is interplay of investigating agencies, CBI, ED, NCB, NIA, and police with reference to the Constitution. I know that everyone is excited to hear from Sir, but since on our platform we have a senior advocate and a former president of Gujarat Bar Association who has been kind enough to share his knowledge on different perspectives of law on this platform, and these have also been well received on the platform. Consequently, though I could have spoken much more, but once I find my elder brother out on the platform and who has been guiding us to share his experience on this platform, and at the same time, welcome, sir. Over to you, Mr. Pandya.
Thank you very much, Mr. Vikas. It is indeed a great pleasure. I am very excited to hear Mr. Shekhar Naphade. So because he is the main key speaker, it would be improper to waste any time for which is earmarked for him. But my experience on this platform is amazing. I am really happy, and I think I have addressed about 4 webinars on this platform, and they are doing very well on the social media, on YouTube, etc. So I welcome Mr. Shekhar Naphade, and over to him because I don't want to waste his time. Thank you very much, Mr. Vikas.
Thank you, sir. Over to you, sir.
Thank you for giving me this opportunity to share whatever bit that I have learned in this profession. Now, today's topic is very vast in nature, and it's not possible to cover all aspects in this one single webinar. But I will try to cover as much as is possible. Let me first begin with the concept of a sovereign state. Every sovereign state has its own code of penal laws. This is one of the characteristics of any sovereign state. And what is the purpose of penal laws? First, to protect its sovereignty, territorial integrity, and the security. This is the primary objective. The second is to protect its citizens. The third is to establish a peaceful regime so that all citizens and all public entities can carry out the development work peacefully. And for this purpose, you need a legal regime. Now, we have several penal laws on the statute book. Now, all these penal laws deal with variety of subjects. Every penal law has its own peculiarities. But we are basically concerned with the agencies or investigating agencies which carry out the investigation into different offenses that are prescribed under the different penal laws. Now in India, we have multiple investigating agencies. First, the local police. Second, the Enforcement Directorate. Third, CBI. Fourth, National Investigating Agency. And the fifth, the Narcotic Bureau. and the officers appointed thereunder. Now we have to grapple with 5 agencies, and the interplay between these 5 agencies often gives rise to problems, complexities in law. I will attempt to unravel these complexities to the extent that is possible for me. Let me begin with first basic concept. Who is a police officer? Now, it's very peculiar that neither Cr.P.C. nor General Clauses Act nor any other law specifically defines what is a police. The reason is it's a common law concept evolved over centuries, and therefore we assume who is a police officer. In short, a police officer, no matter how he is designated, he exercises the sovereign police power of the state. And what is that sovereign police power of the state? First, to arrest anybody if he has reasonable grounds to believe that the arrestee is involved in a cognizable offense. Second, to carry out investigation. Now, investigation takes in its compass variety of things, including arrest, summoning the persons for recording their statements and evidence, seizing documents and articles, in entering into premises for the purpose of finding out any material in connection with the commission of offense, search warrants, carrying out panchanamas, so on and so forth. Now, these are the essential characteristics of a police officer. Now, whether that officer is designated formally as a police officer or not makes no difference. That is why you will find that the officers of the Enforcement Directorate are not characterized as police officers under any of these laws, but they have all the powers of the police officer. Similarly, officers appointed under the national investigating agencies are not described as police officers, but they have all the powers of the police officer. As far as CBI is concerned, it's called as the Special Police Force, established under the Delhi Special Police Establishment Act, 1946. And same thing about the Narcotic Bureau officers. They are also not described as police officers by the statute, but they have all the powers of the police officer. Now, this is a bit of a legal framework with reference to which we have to see the provisions of the Constitution. Now, before I take you to the provisions of the Constitution, there was a very interesting case before the Bombay High Court. And I am informed that a similar contention is raised before the Supreme Court in a suit filed by Chhattisgarh government against the Union of India, where this similar question is raised. I don't have the details, but this is the information that I've gathered. The case arises out of the arrest of one lady known as Pragya Singh Thakur. This is Pragya Singh Thakur versus State of Maharashtra. Now, this accused, along with some other persons, was arrested pursuant to an FIR which was registered sometime in September 2008. It's a case of the blasts which occurred in a place known as Malegaon in the state of Maharashtra. And the Maharashtra police, the ATS, invoked the provisions of the Maharashtra Organized Crime, that MCOC Act. That they were discharged from the MCOC by the High Court. We did not go into that question. The investigation was carried out by the Maharashtra police. They filed a charge sheet. And after the charge sheet was filed sometime in 2010 or so, and before the trial started, this 31st December 2008, the National Investigating Agency Act came into force. The two dates are important. FIR is September 2008. The National Investigating Agency Act came into force on 31st December 2008. That is after the offence was committed and after the registration of the FIR. The central government, in exercise of its powers under the National Investigating Agencies Act, transferred this investigation to the National Investigating Agency sometime in 2011. Now, as a matter of fact, the investigation was over, the charge sheet was filed. Of course, even though the investigation is over in the limited sense, that a supplementary charge sheet can be filed under section 173(8). Now, this action of the central government of referring the case to National Investigating Agency for investigation and prosecution was done without the consent of the state government. These are admitted facts. You are all aware that if a case is to be transferred from the local police to CBI, either there must be the consent of the state government or that a constitutional court like High Court, the Supreme Court, can direct the CBI to take over the investigation. Here there was no order of any court directing National Investigating Agency to take up the investigation and the work of prosecution. The state government also had not given its consent. The order was passed without the consent of the state government. It is in this scenario that Pratna Singh Thakur filed a writ petition in the Bombay High Court and raised number of questions. The first question which was raised was that by National Investigating Agency, you have created a new police force. And the police is not a matter within the legislative competence of the Union Parliament. It is exclusively within the legislative competence of the state. This was the principal contention that was raised. The second contention that was raised was that this power of transferring the investigation without the consent of the state government is something which is an attack on the federal structure of the Constitution. And therefore, this is not permissible. The third contention that was raised was that after the charge sheet is filed and the local police which carried out the investigation does not intend to carry out further investigation, whether the case can be transferred to National Investigating Agency, the contention was that such transfer is bad in law, is contrary to even the provisions of the act in question. The next contention that was raised was that for the purpose of transfer from the local police to the National Investigating Agency, there are no parameters, there are no guidelines, the power is arbitrary. The other contention was that since the Act came into force on December 2008 and the offence it is now appropriate to place before you the constitutional matrix with reference to the legislative competence of the Union Parliament and the legislative competence of the state legislative assemblies. We first go to Article 245, 246, 248, 254, read with the seventh schedule to the Constitution. We'll have a brief look at these provisions. Let's see first Article 245. And Article 245 clearly lays down that the law made by the Parliament shall operate throughout the territory of India. This is what this article says. Subject to the provisions of this Constitution, Parliament may make law for the whole or any part, and the legislature of a state may make laws for the whole or any part of the state. Now, the jurisdiction of the legislative competence of the Parliament is across the country, but the legislative competence of the state is only in respect of its state boundaries. Next is Article 246. Now, Article 246 has to be read with 248 and 254. I don't propose to read them. I'll briefly summarize what is the constitutional scheme that emerges out of reading these articles together. Seventh schedule consists of three lists. That is list 1, the union list, the list 2, which is the state list, and the third is the concurrent list. Now, there are number of entries in the list 1, similarly number of entries in the list 2, and similarly number of entries in the list 3. Now, what is the scheme of Article 246, 248, and 254? The scheme is this, that Parliament has a legislative competence to enact any law which may be in the list 1 or which may be in the list 3 and which does not fall into any of the lists. That is the residuary entry 97 in list 1, read with Article 248, which says that if a particular subject matter does not specifically fall within the ambit of any of the entries, then the Parliament has legislative competence. Now, the question before the High Court was that what is the subject matter of the National Investigating Agency? Whether the subject matter is constitution of a police force, whether the subject matter of the National Investigating Agency is law and order, or it is something else. Now, before I take you to the relevant entries and the reasoning of the High Court, we have to consider the backdrop of the enactment of this law. You are all aware that the November 2008 is the year in which there were terrorist attacks in Bombay, Taj Mahal railway stations, etc. And the Parliament, as a reaction to these terrorist activities, enacted the National Investigating Agencies Act, and it came into force on 31st of December 2008. If you see the preamble of the Act and the statement and object of reasons, it basically relates to the cross-border terrorism, international ramifications or national ramifications of terrorist activities. Now, if terrorist activities have international and national ramifications, obviously the state would not have the competence to enact any such law. This is the background. Let us see whether the principal objective of the National Investigating Agency or the objective is something else. We are all aware that the Apex Court from time to time has laid down the principle of pith and substance. What does that mean? It means that if a subject matter falls within the legislative competence substantially within the purview of the Parliament, then an incidental encroachment or the penumbra of such legislation may fall in the entries in the list 2, that is the entries which deal with the state. Now, these are settled principles. In fact, these principles of pith and substance, and therefore an incidental encroachment on the entry of the other legislative bodies, is a part of the basic structure, constitutional structure in this country. Now, it is in that light, we'll quickly have a look at the relevant entries. The petitioner relied upon the state list, and that list is list 2, and the relevant entries on which the petitioner relied is the entry which relates to the police. Entry 2, list 2, which says police. Second, entry 1, these are the two entries with reference to which the petition was sought to be sustained. Now, if you look at the provisions of the National Investigating Agency, it constitutes in section 3. Let's see what the Act says. And then I'll again come back to the relevant entries. The Act says that the central government, this is section 3, it says that notwithstanding anything in the Police Act 1861, the central government may constitute a special agency, mark the word special agency, to be called the National Investigating Agency for the investigation and prosecution of offences under the Act specified in the schedule. Now, this agency jurisdiction is confined only to the offences which are specified in the schedule, which we now describe as scheduled offences. Now, what are those offences? Let's have a quick look at those offences. First, the Explosive Substance Act 1908. Explosives, bombs, hand grenades, etc. are very often used by the terrorists, and their supply chain can go beyond the borders of this country. In other words, the use of such explosives by the terrorists has national and international ramifications. Second, the Atomic Energy Act, which again has international, national ramifications. Third, offences under the Unlawful Activities Act 1967. These are again activities which pose a threat to the security, integrity, and sovereignty of the state. Therefore, this has national and international ramifications. You will find that every single offense which is set out in the schedule has national and international ramifications. Now, to deal with this, obviously, the state cannot make a law. Does that mean that there is a vacuum? There can't be vacuum because entry 97 of the list 1, read with Article 248, the residuary legislative power is with the Union Parliament. Now, what do we do? Now, we go to concurrent list. Let us have a look at the concurrent list, where both Parliament and state legislature have legislative competence. And I invite your attention to two significant in the list 3. And those entries are criminal law. Mark the word. It says entry 1, criminal law, including all matters included in the Indian Penal Code at the commencement of the Constitution, but excluding offences against laws with respect to any of the matters listed in list 1 or list 2. What does that mean? It means that Parliament and the state legislature have legislative competence, but what is excluded from the concurrent list, entries which are covered by list 1 and list 2, which means as far as list 1 is concerned, the exclusive legislative power is with the Parliament. As far as list 2 is concerned, exclusive legislative power is with the state. What is left out is concurrent list. Now, one of the ways of looking at the National Investigating Agency is the criminal law. If you see all the statutes, these statutes have created new offences which were not within the purview of the Indian Penal Code. The second is criminal procedure, including all matters included in the Code of Criminal Procedure at the commencement of the Constitution. This is entry 2. Now, what is Criminal Procedure Code? I'll come to it a little later. So therefore, these two significant entries are of paramount importance in judging the constitutional validity of the National Investigating Agencies Act and also the Prevention of Money Laundering Act and also the Narcotic Act. We have to read entry 1 and 2 of the list 3 with entry 11A. That is administration of justice, constitution and organization of all courts. Now, if you examine the scheme of all these enactments, you will find that some agency is created to carry out the investigation. Now, if you look at the Police Act of 1861, now I come back to the topic of police because that's the question which has to be answered and which has been answered by the High Court. There is no definition of a police officer contained either in the Constitution or in the General Clauses Act or in any other statute. We go therefore by a basic concept, that is that he is an officer who exercises the sovereign police power of the state. And I indicated to you earlier what is the sovereign police power of the state: to arrest, to carry out investigation, to prosecute, etc. Now, can we say that the officers who are appointed under the National Investigating Agencies Act or under the Narcotic Act or under the Money Laundering Act, they are not police officers? They are. Though they are not designated as such police officers. Now the question is, they have been given these powers, which a police officer has. Therefore, does the subject fall within the ambit of the state list? That is entry 2. The answer, not necessarily. Now, having placed before you these 3 lists, I want to also point out the other entries in the list 1, which are also of equal significance, if not of decisive significance. Now, the brief history of National Investigating Agency Act or the Money Laundering Act or the Narcotic Act, all these enactments have one common feature. And that common feature is that they are all enacted by the Parliament, point number 1. Secondly, they create a special investigating agency, which is distinct and separate from the local police. Third, which is equally important and perhaps of decisive significance, they are all enacted by the Parliament pursuant to international treaties and conventions. Now, what is the significance of this? India is a party to the hosts of international treaties and conventions. Being a part of the civilized international community, India as a sovereign state has undertaken certain responsibilities towards the international community. In addition to its own role as a sovereign state to protect its sovereignty, integrity, and security. Now, some of the entries in the list 1 directly deal with international treaties and conventions. And Article 253 is also of great significance. Now, before I take you to the relevant entries, let us have a look at Article 253. Article 253 lays down notwithstanding anything in the foregoing provisions of this chapter, that is the chapter which deals with Article 244, 245, 246, etc., which delineates the legislative powers of the Union Parliament and the state legislative assemblies. That's the chapter. Notwithstanding anything contained in the foregoing provisions of this chapter, Parliament has power to make any law for the whole or any part of the territory of India for implementing any treaty, agreement, convention with any other country or countries, or any decision made at an international conference, association, or other bodies. Now, Narcotic Act, the National Investigating Agency Act, or the Money Laundering Act, all these enactments are subject matter of some international convention or treaties to which India is a party. So therefore, Article 253 straight away comes into picture. Moment Article 253 comes into picture, then the list 2 recedes into background. Article 253 overshadows the list 2, read with Article 246. This is one way of looking at it. Now let me show you the entries in the list 1, which have a considerable bearing on the issue which we are concerned. First is list 1, first entry, defense of India. And every part thereof, including preparation for defense, and all such acts may be conducive in terms of war to its prosecution and after its termination of effective demobilization. Now it's very widely worded, defense of India. All these terrorist acts is nothing but an attempt to wage a war. If these terrorist activities are allowed to go unabated, the defense of India will be in jeopardy. Therefore, any enactment, if you see Hijacking Act, if you see Narcotic Act, look at any other statute which are brought within the purview of the National Investigating Agency, they have international ramifications with reference to defense of India. Then second, naval, military and air force, any other armed forces of the Union. Third, deployment of any armed forces of the Union or any other force subject to the control of the Union or any contingent or unit thereof in any state in aid of the civil power. 4, naval, military and air force works. 5, arms, firearms, ammunition and explosives. Use of explosives by the terrorists is straightaway falls under the Explosives Act, which relates to the entry 5 of the list 1. Atomic energy, next item. Then item 13, participation in international conferences, associations and other bodies and implementing the decisions made thereat. 14, entering into treaties and agreements with foreign countries and implementing such treaties and agreements and conventions with foreign countries. Next, war and peace. Now, there are several other provisions in the list 1, including foreign jurisdiction, then relations with foreign countries, diplomatic relations, etc., etc. Now, therefore, it is reasonable to assume that these enactments, which deal with international ramifications, because Narcotics Act, you are aware that it's a big international trade, illegal trade. The drug menace in India, especially in certain northern states, is a serious problem. We all know that the cross-border terrorists and the anti-social elements are responsible for this illegal narcotic trade in India. Now, therefore, narcotics is a serious problem all over the world. And that is why the international community, through the member states of United Nations, agreed to enact in their respective countries a law which would deal with narcotics. Now, therefore, it's a subject which falls within the ambit of the Parliament. Similarly, National Investigating Agencies Act deals with very serious matters, the security of the state. If you see those statutes which I have enumerated, these are all statutes which have which involve offences which have national and international ramifications. Therefore, incidental encroachment, the theory of pith and substance, is squarely applicable. And therefore, these laws, though confer powers of the police officers, of the central government, they are valid laws. I have given to you in brief what is the reasoning of the High Court. But the principal reason which appeals to me is this, what I have set out just now. The second reason which equally appeals to me is that with reference to entry 1 list 3, that is crime, what is the significance of that entry? It's a heads of legislation. It enables the parliament or even the state legislative assemblies to enact new criminal laws. Now, enactment of all new criminal laws is a subject which is in the concurrent list, subject to 2 riders, that if it falls under list 1, it is exclusively with the Union Parliament. If it falls in the list 2, it is exclusively with state. For example, I will give you any offense relating to atomic energy. If a new offense is created, the atomic energy falls in the list 1, and therefore Union Parliament alone can create an offense by enacting a new penal law. But suppose a new offense is to be created with reference to illegal transfer of agricultural lands. Agricultural land is a subject under entry 18 of the list 2. And therefore, such a new offense can be created by the state legislative assembly. Now, anything which does not fall in the list 1 and list 2 is residuary entry, Article 248 and entry 97 of the list 1. Now, therefore, the power to create new offenses by enacting new laws is there with the Union Parliament. And the Union Parliament, when it creates a new offense, does that mean that the power to investigate, the power to arrest, the power to prosecute such parliamentary law must confer the power only on the state police? Answer is no. In other words, upon a proper reading of the constitutional provisions, the police is one agency for the purpose of investigation. Now, at this stage, I must deal with the Police Act of 1861. We had series of police acts at the central level. 1861 Act Police, that is the first enactment under which the police force in India was constituted. At that point of time, there was no state government, there was no provincial government. We had a unitary form of government. So there was no question of legislative competence. Then there were police acts of 1888 and 1949, under which certain forces were, police forces were created. But after the enactment of Government of India Act 1935, the constitution of a police force, mark the word I am using, the constitution of police force becomes a state subject. Now, investigation is a matter covered by the Criminal Procedure Code. Right from the earliest Criminal Procedure Code that was enacted in this country. Right from the beginning, there was a clear dichotomy between the constitution of a police force and investigation. the investigation was always under the provisions of the Criminal Procedure Code. It is the Criminal Procedure Code which empowers the police to exercise the sovereign police powers of the state. And it is not by virtue of constitution of the police force by state law. Now, all the states practically in this country have enacted their respective police acts. Like they all correspond to the Central Police Act of 1861. Now, the constitution of a police force is one aspect, and the powers of investigation is another aspect of the matter. The power of investigation is not under the act which constitutes the police force. It is under Criminal Procedure Code. It may happen that these two entries may be combined. That you may constitute a police force and you may apply the Criminal Procedure Code directly or by reference. But the investigation by a police officer under whichever law that is enacted does not relate to the entry 2 of the list 2. It relates to the Criminal Procedure Code, that is entry in the concurrent list, that is entry number . That is entry 2 of the list 3. Now, therefore, let me sum up what I have been trying to put across. That creation of a new criminal law defining new offences is under the entry criminal law, that is entry 1 list 3. Criminal procedure which deals with the procedure which a police officer or any investigating agency has to follow for investigation is criminal procedure, that is entry 2 list 3. Now, therefore, let us have a quick look. The proposition is that a power to enact a new penal law defining new offences carries with it a power to prescribe procedure for investigation. This is the sum and substance of what I have been trying to put together. Vikas ji, do I have some more time? Because this, Vikas ji, can you hear me?
In fact, I also keep myself muted only so that there's no disturbance on your side while you. So it's an amazing session. You can continue. Time is not.
I will take some more time.
So it's fine.
The time permits.
Yeah, 100%.
Otherwise, I will attempt to put it in a capsule.
No, sir. No, sir. No, sir.
Because I thought that the subject is so vast in its scope that to do justice, I may require some more time.
Sir, definitely.
Yeah. Thank you, Vikas.
No, sir. It's a pleasure is all ours. We are learning from a legal stalwart.
Now, I'll briefly indicate that now, as far as CBI is concerned, which is constituted under the Delhi Special Police Establishment Act, under Section 6 of that Act, it cannot investigate any offence which has occurred in the territory of a particular state, unless there is a consent of the state government or the constitutional court like High Court or Supreme Court directs that investigation be taken over by CBI. Now, when CBI takes over, there is no special procedure. It has to follow the Criminal Procedure Code 1973 as it stands. So the CBI is a police officer who is appointed under the Delhi Special Police Establishment Act. So by virtue of being a police officer, he exercises the powers under the Criminal Procedure Code. Now we come to National Investigating Agency. The officers of the National Investigating Agency are appointed under Section 3. That force is constituted under Section 3. Now, under the Act, the officer appointed has all the powers of the police. Let me mark the word, has all the powers of the police. If you look at the provisions of Section 8, even Section 8 empowers an officer appointed by the central government under the NIA Act can investigate not only the scheduled offense, now this is important, or any other offense connected with the scheduled offense. That is the widespread of this act. Now, what is the sequitur? The sequitur is this. If a couple of offenses arise out of the same transaction, then it would be a case of oddity that one set of offenses is tried by the local police, investigated and tried by another court, and the scheduled offense to be investigated by the National Investigating Agency officers. It will lead to anomaly. Therefore, to rule out any such anomaly, the Act empowers the officers of the National Investigating Agency even to investigate the other offenses. The only requirement is that they should be inseparably connected with the scheduled offense. That is one important aspect. The second is they exercise all powers of the police officer, they carry out investigation. Then for such investigation, they have to follow the provisions of Cr.P.C. Now, what is the difference? The difference is this, that instead of a local police, the investigation is carried out by officers of the investigating agency in accordance with the provisions of Cr.P.C. with such modifications as are made by the special enactment. Now then comes, they prepare a report that is to be filed. Now question would arise before which court? Now the National Investigating Agency Act has also created a special court. Now, whatever investigation is done by the National Investigating Officers, it results into a case being filed before a special court constituted under Section 14 of the Act. And Section 14 has to be read with Section 16. The court takes special cognizance under Section 16, and then the trial is like any other trial in a sessions court under the provisions of Cr.P.C. There is one more important provision, that while trying a scheduled offense case, the special court also has jurisdiction to try other offenses which are inseparably linked with the scheduled offenses. Therefore, you will find that the scheme of the Act is perfect. It does not contemplate two trials, one for the scheduled offense and the other for non-scheduled offenses. The only requirement is that both offenses should arise out of the same transaction and they should be inseparably linked. Now we come to PM's Money Laundering Act. Now here also, the officers of the Enforcement Directorate have been given powers of the police officer. Specifically given, if you see provisions of section 16 to 24 of the Act, it Act enumerates the powers of arrest, seizure, survey, etc., retention of record, retention of properties, etc., attachment of properties. And in doing so, they have all the powers of the police officer under CRPC. See section 65 of the Act. Now, how the case goes before the court for trial? It goes before the court through a report or a complaint by the officers of the Enforcement Directorate. The court takes, special court is constituted, and the special court takes cognizance on a complaint by the officers empowered, of the officers of the Enforcement Directorate, empowered to exercise powers under the Act. Then, subject to certain modifications, the special court follows the same procedure as a session court follows for conducting a criminal trial under the CRPC. Now, here also the same provision is there that the special court can try offences which are not covered by the PMLA Act. In other words, not the scheduled offences, but the non-scheduled offences also can be tried by the special court if they are connected with this. The scheme of the Act is that you have the scheduled offences. Now, the scheduled offences can also be tried by the special court constituted under the Money Laundering Act. Now, but for the money laundering offences, the scheduled offences would have been tried by an ordinary sessions court under CRPC. But because they are connected with the Money Laundering Act, all these scheduled offences also fall within the powers of the special court. But technically, two trials are contemplated. Now, this is little interesting. As far as the predicate offences, scheduled offences are concerned, to which the money laundering offences are linked, the normal procedure of CRPC is followed. Whichever, whether CBI investigates or the local police investigates, they carry out the investigation, submit a report under 173. And since these are offences which are linked to money laundering offences, the report goes to the special court. Then the special court holds the trial. And if in the trial, the accused are acquitted, nothing survives under the Money Laundering Act. In other words, the charges under the Money Laundering Act fall to the ground. The trial under the Money Laundering Act survives only if the accused are convicted for those scheduled offences. This is the fundamental difference. In other words, it contemplates two separate trials by the special court. A question arose before the Jharkhand High Court that the charge sheet is filed in the scheduled offences which is submitted by the local police, and the charge sheet is filed also by Enforcement Directorate in respect of money laundering cases. Whether the scheduled offences on the basis of which the money laundering offences are based should be tried first, or they should try together. Jharkhand High Court has taken a very interesting view. High Court says that both the trials can proceed simultaneously. And the conviction and the trial, ultimate conclusion in the money laundering trial would survive only if the accused are convicted in the scheduled offence. This is the peculiarity of the money laundering act. Now we come to narcotics. The officers are appointed, but before I conclude the Money Laundering Act, I must tell you that Enforcement Directorate officers or Enforcement Directorate is not constituted under any statute. Enforcement Directorate was constituted in 1956. It's a part of the Ministry of Finance. See, unlike the National Investigating Agency officers, that force is constituted under Section 3 of the National Investigating Agency Act. The local police force is constituted under the respective police act. It may be 1861 Act or it may be a local police act, like Maharashtra Police Act or Gujarat Police Act. But ED officers, that force is not constituted by any statute. It's a non-statutory directorate which was constituted as a part of the Ministry of Finance. And it's principally in those days designed for revenue intelligence and for the purpose of violation of the Foreign Exchange Regulation Act. And at present also, it monitors the implementation or the violations of the Foreign Exchange Management Act, coupled with the PMLA Act. Now, as far as narcotic is concerned, they are all officers appointed under Section 4 to 7 of the Narcotic Act, 1985. Now, under Section 42 of the Act, they have all the powers of the police officers for carrying out arrest, search, etc., investigation. They have all the powers of investigation of a police officer. Now, if you see the provisions of Section 51, 52, 53, 55, all these provisions deal with how the investigation is to be carried out and what are the powers. Now, therefore, you will see that all these officers of the Narcotic Bureau are specifically empowered to carry out investigation under the 1985 Act, even though they are not designated as police officers. Finally, we have this, here also we have a special court, Narcotic Court constituted under Section 36A. And here also there is a provision that while investigating and while trying any offense under the Narcotic Act, there is some other offense under some other law which is inseparably connected with this offense, then the special court can also try that out. So that the trial will be conducted by the special court in accordance with Cr.P.C. So what is the common feature that we see from all these enactments? The common feature is that Cr.P.C. is the common thread that connects all these officers, whether designated as police officers or not, for the purpose of carrying out investigation. After investigation, the common feature is that the case goes before a special court. And you will find that each act has a special court. Now, what happens if an offense in question falls under all the three? It may happen. And it may also happen that because the offenses are so connected, that the jurisdiction and authority of all the three agencies may be attracted. Or maybe that the jurisdiction of all the three special courts will be attracted. Then that's a case question of adjustment. Which court will have precedence? The National Investigating Agency Act says in section 19 that that act trial will have precedence. Why so? The reason is very simple. Offenses which are to be investigated by the officers of the National Investigating Agency are offenses connected with the sovereignty, integrity, and the security of the state, and therefore the trial under that act must have precedence, and therefore that court, special court, will have jurisdiction which may override. Now, the working of these, we are learning a lot from the working of these enactments. Unfortunately, I don't have enough time because some of the intricacies. One example I will give you. For example, Supreme Court in a recent judgment of 2019.
You can share the insights as long as you want. We won't take the questions. It's better to learn.
No, I'm just indicating. Vikas ji, I'm indicating what are the areas.
That's what I'm saying. We would be more happy to learn from you rather than taking the
I will briefly indicate because I am also getting tired. Because
I understand. A bird eye view would be better.
Yeah. Good time. Now, for example, under section 14, the problems which we may face. Now, under section 14 of the National Investigating Agency Act, because each of these provisions will require a lot of debate and a clarity as because the law is evolving. Section 14 says that any other offense connected with this. Now, there is a section 17 in the National Investigating Agency Act, and its provisions are very interesting. Now, similar provision is not to be found in Cr.P.C. to the extent to which section 17. Now, what does section 17 say? Very important. It deals with protection of witnesses. Now, let me read that section. First of all, the trial can be in camera. A trial under National Investigating Agency can be in camera. The reason is that the offenses under this act relate to the sovereignty, integrity, and security of the state. And therefore, there can't be a public trial. This is not in public interest. This is not in the interest of the security of the state. That is one. Secondly, the protection of the witnesses, their names, their identity can't be published. This is important. Now, subject to this special procedure, the trial is in accordance with Cr.P.C. Now, therefore, if a trial is to be conducted under the National Investigating Agency Act of other offenses which are linked with the scheduled offenses, the accused may contend that, look, I am prejudiced because the trial is in camera, because the names and addresses of the witnesses are not known to me. But in the larger public interest, is it or is it not reasonable to have such a trial in camera? Is it or is it not in the national public interest that the names and identity of the witnesses be kept secret? These are issues because in the Pragya Singh's case, a contention was raised on the basis of Article 14 and 21. Court has not dealt with that very elaborately. And there is almost a very cryptic finding on those issues. But this will require a fuller debate. Because Article 14 and 21 contemplates a fair trial. Now, the parameters of a fair trial may differ from the nature of the case. The accused would contend that it makes no difference to him whether the trial is relating to an offense which relates to the security of the state or an ordinary murder under 302. I must have the same procedure. That's one way of looking at it. The other way is that his rights under Article 21 for a fair trial may differ from case to case. In other words, the public interest, the national interest will have a dominating impact. Now, how do we adjust the dominating national interest and the right of an accused to a fair trial? This requires a lot of debate. This is also related to an in-camera trial. Those of us who remember the trial of the ex-Prime Minister of Pakistan, Zulfikar Bhutto, it was a trial in a closed place. Public was not allowed. It was not even in camera. Nobody knows what that trial was. Now, a completely opaque procedure for a trial would certainly prejudice the accused. It is one thing for a witness to depose before a court which is open to public, and another thing for a witness to depose in a closed atmosphere in the presence of police officers and in the presence of the lawyers. There would be a different psychology of the witness. Now, therefore, these are issues which would require, though the Act says that in all other matters, Cr.P.C provisions will apply, but there are special provisions in all these enactments. This will require a relook or a detailed debate on with reference to Articles 14 and 21. After Maneka Gandhi's case, Article 21 has received a very expansive and a liberal interpretation. The first view in Gopalan's case, that all that Article 21 lays down is that the person's liberty is taken away by a law which is enacted by a competent legislature. The reasonableness of the law was not for the courts to adjudicate upon. In other words, Article 21 does not contemplate that the law which deprives a person of his liberty should be a reasonable law. That sea change came, paradigm shift came after Maneka Gandhi's case, and the court has taken the view, which is followed in a number of judgments, that the law must be reasonable. And the reasonableness of law also applies to substantive and also applies to procedure. Now, therefore, a special procedure, a special police force, or a special investigating agency, whether it conforms to the requirement of Article 21, is a matter which is still being debated in the courts. Unfortunately, the Pragya Singh's case never went to the Supreme Court to the best of my knowledge, or whether it went and it got dismissed, there is no judgment of the Supreme Court. But at present, a similar challenge is pending in the Supreme Court, and let us hope that the Supreme Court decides that quickly as possible. Now, with this rider or with this addition, let me say that the elaborate machinery that has been created for the purpose of National Investigating Agency Act, Narcotic Act, the Money Laundering Act, whether it is possible to have one single code, a single set of officers. Very often, these offenses are interconnected. And then there are problems of coordination between the Narcotic Bureau officers, the CBI officers, the National Investigating Agency officers, the local police. Now, all these are practical problems. Now, how effective is their practical coordination is something that is something to which we have hardly any access. But what emerges in the public domain indicates that a lot is required for their mutual cooperation and coordination. I personally feel that instead of creating special investigating agencies for different statutes, we can have one single agency apart from the police. The local police will remain because the local police is constituted by the local state laws, and their powers of investigation and prosecution are covered by central law, that is Criminal Procedure Code. But the special procedure under the National Investigating Agency Act, Narcotic Act, and the Money Laundering Act, these different sets of officers can be grouped together, and you can create one single cadre or one single force for the purpose of carrying out the investigation that would ensure, in my view, better coordination. Because with reference to all these different statutes, there are different, for example, PMLA goes to Finance Ministry, National Investigating Agency, the Home Ministry, Narcotics to some other ministry. Now the coordination amongst officers and ministries would not be that smooth. This is what the practical experience that we have gained indicates. Vikas ji, now I am tired, I must stop. I must thank you for giving me this opportunity.
No, sir. That only shows your humility. But it was an enlightening session, and we are all indebted the way you have expressed the things. Or this is one of the topic which even at the first blush doesn't seem to be all that simple. But the way you have expressed it only speaks the volume, the manner in which you expressed it. And I'm quite sure that the viewers who are watching us live on the Instagram, Facebook, and the YouTube, and all those are on the platform, would actually be enlightened. At least I feel. So just one question that Prajendra is asking, could you share that judgment which is being pending before the Supreme Court?
I was trying to, there is, I am told, a suit has been filed by Chhattisgarh. I am told that. I was trying to collect the information, but I couldn't get. If anybody knows, the standing counsel for Chhattisgarh, he can enlighten us on that.
We have amongst us Justice Nagamatu, if he's still there, since he's logged in. He also has an immense knowledge, and he has also shared this knowledge on our platform. I will just ask him if the sir can be there.
Just find out, that will enlighten me also.
Justice Nagamatu, sir, kindly come on the video and unmute yourself, sir.
Sir,
the fact that you have been on the platform for so much time.
Sir, good evening, sir.
Good evening.
Sir, wonderful lecture. After your lecture in our Friday group, in our Supreme Court Bar Association, now after a long gap of time because of COVID-19, I could not hear you anywhere else. Sir, really wonderful.
No problem.
Wonderful, sir. Wonderful, sir. Really. Sir, I got only one thing, sir, for your thinking. Sir, you said under all these special enactments, these officers are doing investigation. actually exercising the powers of police.
Yes.
Can we argue that these statements recorded from the witnesses by these officers, or even from the accused, are hit by section 162 of the code?
Yes.
Number two,
They
sir.
are because
Yes.
the investigation is under CRPC.
Yes. Yes.
Yeah, it's under CRPC. Though not by a police officer designated as such. They have all the powers of the police officer.
Thank you, sir. The same view I do have.
Some of the acts,
Yes.
for example, make a departure from the Evidence Act. A confession made to a police officer is admissible.
Yes. Sir,
So
similarly, sir.
those are practical difficulties. As I said, that the spread of Article 21 is very wide.
Yes.
And some of these issues will come up.
Similarly,
Personally speaking, the Bombay judgment has not dealt with elaborately with Article 14 and 21.
Sir, similarly, sir, these statements are called from the accused by these officers are not hit by section 25 of the Evidence Act, sir, at least for the purpose of section 25.
But some of these acts make a provision that that confession made to a police officer is admissible.
In these acts, sir, more particularly in narcotics side, there is no such provision.
Then it can't be.
But there are conflicting judgments from the Supreme Court. And under the Customs Act also, the excise, they are
That is the view taken by the Supreme Court. They are not police officers, therefore it is admissible.
Yes, that is a problem, sir.
That is a big problematic issue. I am not personally comfortable with those judgments.
Yes, I do, sir. I do, sir.
Because what is a police? Therefore, I said there is no definition of a police officer anywhere.
Yes.
It's a common law concept.
Yes, except his
Who is a police officer? One who exercises sovereign police power of the state. And what is sovereign police power of the state?
Prevention and detection of crime.
Crime.
That is what is the purpose, the object behind the Police Act also. So therefore, sir, any officer who has been vested with the power to prevent and detect a crime is a police officer.
Yes. How?
Yes. But the Supreme Court, sir, consistently has been taking a different view. And now, sir, under the Narcotics Act, accused are convicted solely based on the statement said to have been given by the accused to these officers.
See what happened to Tada and Putta. That police officers became so complacent that they would get only the confession from the accused and not bother about other independent evidence to corroborate at least in material particulars. Ultimately, that committee had to be formed and people had to be discharged. We know all that. Therefore, fair trial, the parameters of fair trial is an issue under 21.
At least under the Third Act, sir, there is a provision which says that confession can be recorded by the police officer after following certain strict procedures, and therefore it is admissible. And the bar under section 25 is done away with. So at least there is a provision. Whether the Supreme Court has upheld the validity of that.
If you find judgments and Evidence Act under 27,
yes,
you will find a lot of conflicting views, because the scheme of Evidence Act also for last more than 100 years we have not been able to. So the statement is true.
Sir, in my
discovery of fact.
Yes, sir.
Yeah.
Conflicting views are from the Supreme Court only recently, sir, not before. After 1947, so far as section 47 is concerned, 27 is concerned, law was settled. After
you will have to unmute yourself.
Me?
No, Mr. Shekhar. Yes, sir. Yes.
Sir, at
I
least
couldn't get the question.
Sir, after 1947, Pulikuri Kotaya, at least the law relating to the discovery of a fact was settled. But many of the court do not understand the import of section 27 in the light of the law laid down by the Privy Council. So
but I will tell you one thing.
Yes, sir.
That law is clear.
Yes.
It's practical application.
Correct.
How do you dissect?
Correct.
How do you dissect the statement?
Yes.
And there is one more interesting dimension, if I may just incidentally mention.
Yes, sir.
Now, what is discovery of a fact? Does it mean a tangible thing? In one case,
yes,
the accused took the police
yes,
to a place where another person was found in possession of counterfeit currency.
Okay. Yes, sir.
The discovery of that accused,
Yes.
is it under 27?
Yes, it's falls under 27. Sir, one more case.
There was only one Allahabad High Court judgment, which is affirmed by the Supreme Court. Some High Courts had taken a different view. They said, no, this is not discovery of a fact. Anyway,
Sir,
the point is that a fair trial is a very vast subject, and some of these provisions, in the light of the narrow view that Supreme Court has taken of the concept of a police officer, they have to be revisited.
Correct. Sir, only lastly, sir, if you could bear with me for 1 more minute, sir.
Yes, sure.
Only one. Sir, in a case, there was a complaint of missing of a person. So the accused was arrested on suspicion. He made a statement that so-and-so was killed. So subsequently, it turned out that really he was killed. Now, whether this statement, with the discovery of the fact that man was no more, will fall under section 27, sir. Until then, the police have nobody knew that the man was no more. The fact that the man was no more.
Statement.
Yes.
The statement.
Yes.
And the discovery that the man is no more must be proximate in point of time.
Yes. It was proximate.
If it is proximate in time, it may fall under 27.
Yes. But dead body was not discovered on the statement.
But that we know that now corpus delicti, even if not found, if there is sufficient evidence.
Correct. Sir, what was discovered out of his confession was a newspaper where there were stains of blood of the deceased. That was proved to be that of the deceased later on by this DNA examination. So
these are all matters which will depend upon the factual matrix of each case.
Correct. So one interesting question arose whether this statement, which leads to the discovery of the fact that the man was no more, would fall under section 27. I held yes, it falls under section 27 because there was a discovery.
Provided it is proximate.
Yes, proximate and immediate.
Suppose the man says today and after 10 months you discover that that man is no more.
No.
It can't relate.
Yes, some discovery of fact. Yes, sir. Yes, sir. Thank you, sir. Thank you so much, sir.
My pleasure. My pleasure.
Thank you, sir. Thank you. Sir.
So we all know that Justice Nagamatu's webinars and seminars, initially they were all hit in Madras High Court, but this, as they say, new is the normal. His webinars pan India are immensely popular, and we are too happy to share with all those who are watching us that his webinars, which he has shared on BeyondlawCLC, Justice Nagamatu's webinars, are doing immensely well on the YouTube channel. So I will just take 2 questions since we are running out of time. Nikhil, after how much time limit is it necessary for the investigating agencies, that is local police, to record statements of the complainant and witnesses made under Section 161 CRPC?
Now,
and
section,
Section 161.
first of all, there is no time frame to complete the investigation. Only 167 CRPC says, so 167(2), that what we call as the default bail, that in case of serious offences, if like 302, if the investigation is not complete within 90 days and charge sheet is not filed, then the accused automatically gets a right of bail. And in other cases, 60 days. Now, or did I say 60 days and 90 days is the default bail ground? Now, this question was raised years ago, that if suppose investigation goes on and on and on, there is no time limit, then all that would happen is that accused would get a right to bail. But I have not come across any judgment which says that if it is not completed, then it can be quashed. This is again a dimension of Article 21. How long can you keep a man under the threat of prosecution? All that the high courts have been doing is directing to finish it within time, they can take contempt action, and somehow then some kind of charge sheets are filed. It becomes a very shoddy business.
So this is perchance by my namesake. Is it necessary to obtain permission from the competent authority in case of crime investigation agency involved in local police in investigation of any crime?
Require the,
Just told me.
I couldn't get the question.
So I'm repeating it.
Yeah. Hello.
Yes, sir. Is it necessary to obtain permission from the competent authority in case crime investigation agency involved with local police in investigation of any crime?
Now, for example, some of the provisions require a prior permission for an even investigation. That depends upon each and every statute. But otherwise, a cognizable offense means a police officer or a person who is authorized to investigate can arrest without warrant and start investigation, unless there is a specific bar.
Yes. So this is the last question we are taking. This is by Risha Sharma. She is a second year student. Coordination of police officers with these special agencies, like sometimes, is malified act of police officers during investigation, which later lead to need of special agencies and later where government also defends the malified. So another question is, are these agencies really working independently? These concern issue come in my mind while reading ISRO Nambiar case. This is just one of the case where government was not agreed to concern with the CBI case.
Let me answer this question with a wider philosophical perspective. I remember the judgment of the International Court of Justice. The continued presence of South Africa in Namibia, the expression used by the International Court of Justice was that they were supposed to be there for a certain period. And what the court has described is a beautiful phrase, that this was a sacred trust of civilization. That you have been entrusted this job, it's a sacred trust. Similarly, a police officer who is invested with the sovereign police powers of the state is discharging a sacred trust. And therefore, any dereliction in his duties would invite applicability of offenses under the IPC. It may be an offense of destruction of the evidence. It may be an offense of shielding some accused. It may be an offense of fabricating evidence. It can lead to number of different offenses under IPC. It is not unknown that police officers have fabricated evidence. These are matters which have come and recognized by the judicial authorities in their judgments. So therefore, while carrying out investigation, the special agencies may look also into the role of the concerned police.
Yes. So
The Telgi's case is a classic example.
That's true. So thank you, sir, for the insights which you have given to us. As I initially said, and at the end of also the session, we are saying that you have actually given us, I'm just unmuting Justice Nagamatu, probably he also wants to express something. Okay, he's switched the video. You have expressed it in a way, as we in normal law, we say that the expansion has been given in an extensive and an expansive mode. And we couldn't have got a better insights on this topic that I can share it on behalf of everyone. And since Justice Nagamatu is a part of this session, we will ask Justice Nagamatu to give the ending remarks. Over to you, sir.
Mr. Vikas is one of the beneficiaries of today's lecture. I, on behalf of all the beneficiaries like me, immensely thank our speaker who has given a lot of insights into the difficult areas in the criminal law. And I also express my thanks to Mr. Vikas for continuously and tirelessly taking up the job of educating the legal fraternity by conducting these webinars. I think that you have crossed around 100.
No, sir, this is 200th.
200. 200. Thank you, sir. Thank you, sir. Sir, Senior Counsel.
Thank you. My pleasure also for uh, giving me an opportunity to re-equipping myself with.
Yes. Thank you, sir. Thank you, sir. I am in
Okay.
Chennai. So the moment I saw that you are going to speak in this webinar, so
I'm stuck up in Bombay.
okay, I know. I know, sir. I got ready, sir, well in advance, not to miss even a single word that you are going to speak.
Okay.
Thank you, sir. Thank
Okay,
you so much.
Vikas ji, thank you.
Thank you, sir.
Yeah.
And tomorrow's session, only 1 minute. Tomorrow's session would be a master class on law of divorce. We have already had part 1. That is overview part 2 by Ma'am Aruna Farswani, who is a principal judge in Family Court, Thane, Mumbai. So do join us tomorrow at 4 p.m. Everyone stay safe, stay blessed.